Good evening, everyone, and welcome to the 2023 University Lecture. I'm Ken Freeman, Interim President of Boston University. As many of you know, the University Lecture spans 73 years, spanning back to 1950. It was established as a way to honor Boston University's most distinguished scholars and researchers, and to bring their work to the attention of the university community and the broader public. The University Lecture is a wonderful tradition which we continue this evening. Reviewing the list of the earliest presenters, and you can find the list in your program, you'll see that they, then as now, lectures have been drawn from across the university, across the many, many academic disciplines, from the humanities to biology to social sciences to medicine to the professional areas, and much more. BU has an abundance of people seeking answers, not always easy answers, rather impactful and illuminating answers. They do this using the means and methods of their disciplines, and sometimes they travel to the outer borders of those disciplines to see what they can learn from outside their particular area of focus. For example, at the Center for Computing and Data Sciences, our researchers harness the massive and constantly expanding power of advanced computation to mine the resources of information now collected to see patterns and understand problems across all of the disciplines. Our speaker this evening, Jasmine Gonzales Rose, is Professor and Associate Dean for Equity, Justice, and Engagement at the School of Law. She's a founding faculty member of the BU Center for Anti-Racist Research, where she led legal research and policy projects for 3 academic years. Her scholarship examines the intersections of racism and linguicism with juries and evidence, and she is a leading criticalist voice on evidence law and juror language disenfranchisement. Professor Gonzales Rose is an award-winning educator, having taught evidence law, criminal law, civil procedure, complex litigation, racism in the law, Latinxes in the law, and civil rights law. Is there any course you have not taught, Professor Gonzales Rose? Prior to joining our faculty in 2020, she was a professor at the University of Pittsburgh School of Law for nearly a decade. She's a graduate of Harvard Law School, where she served as editor-in-chief of the Harvard Latinx Law Review and a member of the Harvard Legal Aid Bureau. This brief account of her credentials and accomplishments is by no means comprehensive, but then again, you came here tonight not to hear from me, but to hear from the professor. The title of Professor Gonzales Rose's lecture is Unifying Concepts, Critical Race Theory, Academic Freedom of Speech, and Democracy. Through her lecture tonight, Professor Gonzales Rose will address a number of questions, including what is critical race theory? How can teachers, learners, and community thinkers tangibly apply critical race theory? Why is critical race theory important? How does it benefit education, law, and society? How is it a form of epistemic justice, student empowerment, and social change? What are divisive concepts laws and other attacks on critical race theory? Why are the attacks happening? Why do attacks on critical race theory violate academic freedom and freedom of speech and education? And as a university community, how is the teaching of critical race theory core to our values? How can it be unifying rather than divisive? It's my pleasure to present this year's University Lecture, Professor Gonzales Rose.
Good evening. Oh, goodness. We're in law school now. Good evening. Good evening. Oh, my goodness. It's BU community. We do it right. We do it right. Thank you so much, Professor Freeman. It was amazing to be introduced by you and to be sharing this space with you. I also want to thank Provost Luchin as well for being here tonight. I want to thank former Provost Morrison, who I'm told that this was one of her last things she did. And I would like to thank the former committee of chair, Josephine Halverson, who delivered the lecture last year and chaired the selection committee. I want to thank Megan Fernaro from the Provost's office. And I want to thank all of my faculty colleagues at law who nominated me and faculty across the university, who truly inspire me every day. I'm particularly honored to be here in the presence of my dean, Onwachi Willig, because she's a leader in critical race theory. And what a pleasure to be able to grow as a scholar, as a teacher, as a leader with your example. I would like to thank all of my close colleagues that I've worked with across the university at the BU Center for Anti-Racist Research, who have taught me so much about race and racism. And I particularly would like to acknowledge my research assistant, Kate Blankenship, who literally makes this possible to do this today with both doing a PowerPoint in an airport, finishing some touches last night, as well as just being such a great thought partner. So thank you so much. And I particularly want to thank all the students, because that's what inspires me every single day, are the students. And so you are amazing. Thank you for being here. With special thanks to the equity fellows that we have at the law school, who are peer fellows, Chelsea Wang and Aiden Henderson, for all your encouragement and support. And the biggest thanks goes to my mother, who is here tonight. And to my children, Sol and Oceana. So there's this expression I have never, ever understood, which is people would say they are honored and humbled. And every time I'd hear that, I would think, no, you're honored. You're not humbled. Let me tell you, I understand that tonight. I feel tremendously humbled, because no matter what I say, if I speak about constitutional law, and I will, there are people, and I know them by name, who know it better. When I speak about history, there are people here who know it better. When I think about philosophy and epistemic justice, people in this room know it better. There's very few. There's maybe 2 points, and it's only because I made up those words myself that I know it the best, right? And I almost got a kick out of, that when President Freeman said she's an expert on juror language disenfranchisement. It's because nobody else really cares. But so I feel so humbled, and that's why I want to emphasize that tonight is the university lecture. It's about the university here, because as scholars, and as teachers, and I'm going to talk a lot about teachers, and there's so many people who are teachers here that they're faculty, but there's also the teachers who are graduate students, and there's teachers here who are, undergraduate students who are doing so much mentorship that I hear about across BU. So many of us are teachers in so many different ways. We're teaching each other, we learn from each other, and I'm so proud to be able to be here and share with you. And tonight I'm going to share a few different things. I'm going to share a little bit about my journey to CRT and my journey within the academy over the last 15 years, and really center it with some of those questions that President Freeman articulated here. So in some ways, my journey has been an untraditional one. And I have to tell you, I thought I was over feeling like I was out of place, until I went into we had a law school gathering, and the dean said a few words beforehand, and I looked around and I said, why me? Why would I stand on this stage? And so I want to dedicate tonight to anyone who feels this way, and I really want to emphasize how who we are can form the questions that we tackle in our career. And these may be questions that we tackle in our research, in our practice, in our service, in so many different ways. So my path was unconventional in some ways. I share a little bit of my story in the brochure, but how is someone who experienced rather severe poverty growing up, so for someone who experienced housing insecurity, food insecurity, who dropped out of the 7th grade, how am I here today? Well, part of my journey is untraditional, but I feel like it's also really what brought me to critical race theory. I questioned injustice around me. I questioned it, and then I was given an opportunity to have a language to understand these experiences. And this language was through CRT. So for me, initially, being an activist and then being an attorney, a scholar, started out about being a survival. Now it's not so much survival, I could do other things, but it's what feeds me. It's really, really what feeds me so much. So here, if I'm thinking about, I want to talk about my journey. I want to talk a little bit about what CRT actually is, the attacks on critical race theory, some of the legal challenges that are being brought, and then come to some unifying concepts, which I feel really are about academic freedom, democracy, and ultimately really love. But it's that concern and care for our communities. So CRT gave me language. It gave me the theoretical conceptualizations of lived experience. This can be used to understand, to organize, and to advocate, and ultimately to change law, policy, and practice. And I wonder if that's one of the reasons that CRT is viewed as threatening. Now, CRT became considered a national threat by some when protesters with Black Lives Matter and so forth, after the murder of George Floyd and Breonna Taylor and others really came to light. And people in everyday discourse began using some of the terminology of critical race theory. Now, I'm thinking about my journey. One thing I experienced that I understood was linguistic discrimination. So that could be being put in special education because of the way I spoke, or it could be that people assumed I didn't know English, or it could be that when I went to take the LSAT and took a prep course, well, you know, you're never really going to do very well at that. You're never really going to get into a law school because English is not your first language. Now, you've heard me talk for a few minutes. You can tell I'm a native English speaker. But there's something so tied with being Latina, being Chicana, and language. And so I was thinking about that. I really thought about that quite a lot. You know, I was thinking about how can the legal system be better equipped to address race discrimination outside of the black-white paradigm. It was something I started thinking about even in college. Another thing that I thought about that really came to bear was I worked a lot with survivors of sexual and domestic violence. And that's what ultimately brought me to law school. I would meet with survivors, and survivors would share their truth, their experience. And that's ultimately the evidence that's needed, whether it's a prosecution or a protective order. But when the attorney arrived, they were not situated to share that. They didn't feel safe to share that. The questions didn't elicit that testimony, that evidence. And so I really started thinking about how are, and a lot of the clients I worked with were from different minoritized backgrounds, how are minoritized people's experiences known and believed under the law? So these are two questions that I want to explore, I want to address. And that's one of the things that brought me to juror language disenfranchisement. And I remember the precise moment that I thought about, you know, I had my own experience of how race and language intersected. And I was clerking at the U.S. District Court for the District of Puerto Rico, and there in the federal court, English is the official language. There are juror language statutes, requirements across the country in most jurisdictions, not all, but the vast majority, including in the federal courts. And there was a court personnel who said to me, I was clerk there working in chambers, said, Mira, look, come look. that juror looks like a defendant. And in that moment, I knew what she was saying to me. She was saying that that juror is a Black Puerto Rican. And there are not many jurors who are Black, although they're disproportionately represented over at the defendant's chair trial. And there I really thought, wow. I mean, jury service. When we think about our democracy and we think about our democratic, self-governance and so forth, what could be more important? I mean, voting probably, but jury service is really up there. And so that, I started to hone in on that and think about that quite a bit. So I've been exploring juror language disenfranchisement, and one of the reasons I think that it's so interesting is people say that you can't say someone can't serve on a jury because they look like a racialized minority. But if they sound like a racialized minority, that's allowed in some ways. And so here we can look at kind of the scope of the law. And this is just an example of how do we orient race with this? What tools do we use? So for instance, limited English proficient persons. There are about 11 million US citizens who are limited English proficient who may not be able to serve on a jury, so they would be barred. There's also a case of Hernandez versus New York, where bilingual Spanish-English prospective jurors were struck. They were thrown out of the jury pool because they were bilingual, and there was going to be some Spanish language testimony. And so they were removed because there was a fear. The prosecutor said, look, I believe in their hearts of hearts that they would try to follow the English language translation of the Spanish evidence. However, how do you do that? And that makes you question, well, why is it different? Why is that evidence different, right? Shouldn't you be able to follow that? Aren't the translations? But this gives us a sense of the superiority of the English language, that a mistaken translation would be more important than the original, more accurate evidence. So we've seen that, and what's interesting in this case, and one of the reasons I say it's race-based, is that only the Latino prospective jurors were asked, do you speak Spanish? Now, Spanish is a very common language, right? There could be other jurors of other racialized backgrounds who may have spoken that. So here we have English-Spanish bilingual folks can be struck from the jury, and this is, Hernandez versus New York is a Supreme Court case. This is not just some little case. And then there is folks, English with a Hispanic accent. An example of this is Commonwealth of Connecticut v. Gould, so nearby here, where a juror answered over 100 questions, over 20 minutes, didn't miss a beat, but spoke with a Hispanic accent. And the judge seemed uncomfortable with that and ultimately struck the juror saying, well, will the other jurors understand him? What's interesting is in that area, about almost 50% are Latino, about 45% are Latino. So who is getting into those jury pools here? And then there's some really interesting social science that says that my experience is not an anomaly, where people assumed that I couldn't speak English or heard an accent that wasn't a native English speaking accent. And what about this potential for monolingual English speakers being excluded? So to explain that and to think about that, I had to rely on critical race theory in thinking about, well, what even is race? And I want to talk to you tonight about what even is race. Right? So juror language requirements are procedural rule. And often we think, well, procedural rules, they don't have any racial implications. Another type of procedural rule are evidence rules, right? And I'm sure many people know what evidence rules are. If you don't, that's when someone jumps up and says, objection, right? And then then they should say objection and then give a reason. I tell all my evidence students, After this class, no one's going to want to watch a TV show or movie with you because you'll be so irritated by things like that, right? Things like that. You need to say a reason why, and those reasons are evidence rules. And evidence rules are kind of wielded like swords or shields to bring evidence in or keep it out. They create this limited factual universe upon which people who are fact finders, the jury, can determine a case. It's not about the truth, it's really about what one can prove in court. How they prove that is supposed to be through evidence, right? So how are minoritized people's experience known and believed in law? How does it come to be that evidence is brought forth? So how is race and racism understood under the law? Something I'm really, really interested in. You know, historically in the 18th century, really through the mid-19th century and even the late 19th century in some places, there were race-based witness competency rules. And under these rules, people of color could not testify. Sometimes not at all. Sometimes they simply couldn't testify if against a white person. And here there were statutes. They usually focused on black, mulatto, it was a term that they used, and Indian for Native American. But this was extended to many different groups. There was a case in California where a Mexican American was excluded because the idea that they were mestizo, that they were both Spanish and Indian, and the statute said no Indians. Well, you know, this individual was a judge, okay? And there's also a very famous case of People versus Hall, where a Chinese minor had been killed, and there were only Chinese witnesses. And here I'm not saying Chinese American because at the time, people of Chinese descent were not, they were not allowed to be citizens because only whites could be citizens. And let's think about that, this construction of whiteness and how how that plays into our justice. So here, in this case, and there's also another case I want to talk about in a minute, but in People v. Hall, they said, well, no, they don't talk about Chinese, people of Chinese descent. They don't talk about people of Asian descent. However, we can understand the law to mean non-whites, right? So these witnesses, and because it was a highly segregated racial environment, which was very true then, in some ways is true now, often crimes could occur. There was another crime, it's a US Supreme Court case from 1871 called Blue versus US, and that was a horrific murder of multiple generations and of black individuals by a white individual and two white individuals, and the eyewitnesses were all black. And so here, when people don't have full competency to testify, then horrific things can happen. And so one of the things I've been really interested in my career is asking, is there a dual race evidentiary system? Does that continue in some way today? Do people of color carry an unfair evidentiary burden? So in my scholarship, I argue in some ways they do. Of course, we do not have, thank goodness, explicit race-based witness requirements. Our law is colorblind in that way, right? However, there are several ways that I've seen this play out. One is racial character evidence, where the race of someone is really used as their character. Now, we're not supposed to judge people by their character in the law. We're supposed to judge them usually about what they did. But sometimes we see this happen, and we see it in a couple of ways. One is this kind of inherent reliance that someone is a more criminal, less criminal. Someone's more credible, less credible. Someone's more dangerous, someone's less dangerous, based upon race. Often this may be unconscious or not stated, but there are cases like Pino Rodriguez versus Colorado, where a juror made this more explicit. A white juror in that case, and it concerned some sexual harassment claims. I hope people are being disturbed. There's a little microphone feedback there. It was against a defendant who was a Mexican lawful permanent resident of the United States. And the juror said, I think the defendant, Peña Rodriguez, did it because he's Mexican. And Mexican men take whatever they want. And so here this reliance on, because of his racialized background and these stereotypes about this background, that he was guilty. There was also a witness who was a lawful permanent resident, also from Mexico. He's, I don't think he's credible because he is an illegal. And here, we have this racial slur, this racialized slur, really tying credibility with this slur and also something that was not accurate at all about his status. It's not always this overt. Sometimes racial stereotypes are really inflamed by counsel even. And so we have some examples of this in the George Zimmerman trial for the killing of Trayvon Martin. The defense counsel, George Zimmerman's counsel, tried to introduce various images of young Trayvon Martin. Some of these were with certain types of dress. Some of these were with screenshots of language that was, would be considered a slang language. A picture of just a firearm, not knowing who was holding that firearm. Cannabis in a picture or something like that. So this idea of racial stereotype evidence is that here it's an attempt to persuade the jury that a minority, a minoritized person is that type of minoritized person that has these sort of negative racial traits and inflaming that. And that happened a lot in another case where a police officer, a white police officer named Darren Wilson, had grand jury proceedings concerning killing 18-year-old Michael Brown in Ferguson, Missouri. And here, during the grand jury proceedings, he gave this narrative that really played into these tremendously racist tropes about black people, black men being, and this is another very racialized, slur, and a thug or a brute. And so here he gave this story about how he felt like, he said he felt like a 5-year-old holding on to Hulk Hogan. He talked about how when he fired the weapon and shot Mr. Brown, that young Michael Brown kept coming at him like he was just more angry, and how he was grunting, and how he was really unstoppable by bullets and so forth, playing into this racist narrative here that really dehumanized. And that's what racism really does, is dehumanize. So that's another type of racial character evidence. And sometimes there's another type, which is lay opinion. So in the Peña Rodriguez case, that juror I was talking about, he had formerly worked as a police officer, and he talked about, I was a police officer for these decades, and during those decades, 9 times out of 10, he said, Mexican men were guilty of harming women and girls because they have a certain bravado, they said. And so this idea that from his expertise that he could say these things. So none of this is permissible, but these things are happening, right? Race and racism itself are taking on this sort of evidentiary value. They're being used as what we call de facto evidence, not formal. But this happens, and this can lead to an unequal evidentiary burden. But I've also seen that this unequal evidentiary burden is particularly prominent as it relates to proving the existence of racism. So here I'm thinking about what I call racialized reality evidence here. And there's this phenomena where it's given implicit judicial notice. So things can be implicit, they can be judicially noted, like Boston is the capital of Massachusetts. That can be noted. But here, and I'll give an example. An example would be black and brown flight from police officers. So that can be argued, oh, well, the individual ran because they saw a police officer and they were trying to avoid them, and therefore that's evidence of a consciousness of guilt. And if they had a consciousness of guilt, then they were more likely to be guilty, right? And so it's relevant there. Well, what about the experience, the racialized reality of people of color who may be avoiding police or law enforcement interaction because they fear police brutality, racial profiling, and so forth? Now, Massachusetts has really been a leader. There's a 2016 case of Commonwealth versus Warren, where the Supreme Judicial Court said precisely this, and really was a nation leader in saying, well, it's natural for people of color to be avoiding the police. That shouldn't just be an inference of guilt. There's also, when we're thinking about, okay, there's an unequal burden, how do we make it more equal? How do we think about anti-racist evidence? How do we put on showing that people may run because they want to avoid an interaction with law enforcement? Perhaps they come from a mixed immigration status family and they don't want to bring law enforcement into their lives and risk that family members would be exposed to some kind of immigration proceedings. There's a lot of reasons. One way to do that would be to go through an expert witness. It's not ideal. Expert witnesses are very expensive. Expert witnesses also are not racially representative in so many ways. But it's something interesting to think about, and that's one of the projects I'm really working on now with my co-author, Assis Bassin. Really thinking about how can experts talk about racialized reality? How can experts bring in evidence of racism into the court here? This could be showing how cross-racial witness identification is unreliable. It could be talking about how racial trauma impacts an individual such that they would feel like they need to avoid the police. There's so many ways that they could do this. And we've surveyed over 700 criminal defense attorneys, really gotten some very rich feedback about how this evidence is needed and what could happen. But then we also have to think of, it's not just expensive, it's not just it's hard to find somebody, although the universities are full with people who could potentially be experts. So think about maybe someday volunteering and just planting that seed there. But what about the admissibility hurdles? There was a case here in 2021 that came before the Supreme Judicial Court in Massachusetts, the Hines case, where at the district court level, a witness was not allowed to testify that a tattoo that the victim in a criminal case had was a symbol of a racist organization. The defendant in that case had the defense of self-defense, and their narrative was that there was a race-based kind of scenario where they had to defend themselves, and they wanted to show that racial animus of the victim. And so the tattoo was very important to that. At the trial court level, that was not allowed. But because social science standards are a little different than some of our hard sciences, and a lot of the expert witness tests really focused on those kind of hard sciences. And in the Hines case, once again, the Supreme Judicial Court of Massachusetts really was a thought leader. So surveyed courts across the country and in different federal circuits looking at these different standards. Now, in all of this, thinking about how does race and racism play a role? In all of this, I really leaned on critical race theory. And so sharing a little bit about my journey, a little bit about my research, I want us to all kind of transport ourselves to what was known as kind of that big, some people would say it was a big ugly building. It's beautiful. It was the Law Tower, but then we have the CDS building, the kind of Jenga building, and no one talks about the Law Tower anymore. Now we're classic in this brutalist architecture. Let's transfer over there, and I want to invite all of you to come to law school. Is that okay? All right, okay, let's all come to law school. And so here, let's talk about critical race theory, and let's talk about what it really is. So race, what is race? So race is a social construction that categorizes groups of people loosely based on certain phenotype and perceptions or misperceptions of broad stroke ancestral origin. This is often confused with ethnicity. Ethnicity is one's culture, traditions, or heritage, often related to a specific geographical area. It has to do also with our linguistic usage, our language, our religion, our faith, our spirituality, our customs, our dress, our expression. And then there's national origin. National origin refers to the nation or country where a person or their ancestors were born or originated. So these terms are often used interchangeably. So I just wanted to have some definitions. These definitions aren't too hard. You know what's a hard definition? Racism. Racism is a really hard definition. Why? Because so many people mean different things when they're saying it, including in the law. Okay? So it's so important to know what these different definitions are. Now, I put one definition up here just kind of start us off here, which racism is the idea that one racialized group is superior or inferior to another, and it's also conduct or policies which exclude or harm a racialized group, typically a minoritized or marginalized group. Modernly, there's this idea that there are different types of racism: individual, internalized, structural, which could be institutional, or systemic. So, but these vary by perspective. They really vary by perspective. And so here what we can have are the kind of three primary perspectives that we see in the law. So the first one here is the traditionalist perspective. And it's only big enough for me to read without my glasses on the screen here, so I'll see this. So thank goodness we have this big screen. So this is an idea that since there is formal equal opportunity, the legal system is fair. So since we had Brown versus Board of Education, since we had President Barack Obama for two terms, then the legal system is fair. Now, racism still exists, but only in individual forms of overt racial hatred, institutional action that is race conscious, and recognition of racial difference over similarities. The law should be colorblind, so no recognition of racial difference, and the government should remain neutral as to matters of race. Racial disparities are the result of individual behavior and bad culture. Accordingly, remedies should be internal. So here's self-help and so forth. This is a very prominent view that we have in the law and in society and so forth. And when I'm talking about these, I wanted to really express how much and how important these definitions are to people. And I've really come to respect that. There's also the reformists here. So the reformists say formal equal opportunity is a sound policy, but racism still exists in multiple forms: structural, institutional, and individual. It manifests as both unfavorable treatment and impact, and is situated in a historical context of discrimination against people of color. An important function of law and government is to ensure racial equality. Racial disparities are a result of a combination of internal and external systemic reasons. Remedies should be a combination of external and internal. limited race-conscious remedies to lower or eliminate racial barriers can be appropriate. Another very prominent view. And then let's get into the criticalist view here. Formal equal opportunity is insufficient. As racism and other forms of subordination are embedded in the law and society and serve to preserve power and the status quo for privileged insiders. Racism has different manifestations, but is primarily structural and unconscious. As law and society are not neutral or objective when it comes to race and other traditionally subordinated or marginalized identities, the government and law should address racial and other equity for all people. Racial disparities are a result of problems in law, policy, and other systems and institutions. Thus, remedies should focus on laws, policies, systems, and institutions, and race-conscious remedies are appropriate to remedy past and present injustice. Oh my goodness, I just read so much at you. I'm sorry about that. But I feel like these definitions are so important because we see how much they really differ, right? How much they really differ. And to give an example of this, I think looking at the SFA case against Harvard and the University of North Carolina is a really good example of where we see examples of these different perspectives on race. So when we're thinking and people are talking about racism, that we're not talking over each other. So here we have a very traditionalist viewpoint from Chief Justice Roberts writing for the court, and of course this is the opinion that said that, that race-conscious admissions practices are unconstitutional. And so here are just a couple of examples. And see how some of these values play out here. So we have Justice Roberts talking about, oh, I can see now. We have time and again forcefully, they don't let you do their university lecture until you get old enough that you need glasses. So it's a coming of age. So we have time and again forcefully rejected the notion that government actors may intentionally allocate preferences to those who have little in common with one another but the color of their skin. So, and he talks about when a university admits students on the basis of race, and I think many admissions folks would take issue with that since it's a holistic review that was happening at Harvard and UNC, it engages in offensive and demeaning assumptions. So really seeing that any race consciousness is demeaning to the individual here. We have Justice Thomas writing a concurrence, so agreeing, but wanting to write separately and having a lot to say here about this, talking about objective grading scales and how I think grades, GPA, standardized testing and so forth, ideas of being great equalizers. And he talks about, the 14th Amendment, the Constitution gave us a way out from all of this race discrimination, which is a colorblind Constitution that requires the government to at long last put aside its citizens' skin color and focus on their individual achievements. So here we just traditionalist examples. And then we have dissents by Justice Jackson and Justice Sotomayor, talking about, well, no, there's this reality that racism continues. So simply by deeming race irrelevant, Justice Jackson tells us, it doesn't make it so. Justice Sotomayor talks about this as well. She really talks about how racial equality cannot be achieved without making room for underrepresented groups that for far too long were denied admission through the force of law here. We only with eyes wide open to this reality can the court carry out its guarantee of equal protection. This reformist view is really steeped in history, really steeped in the context of racism continuing, that these vestiges are ongoing and so forth. So we see these examples here. Now sometimes it can be a little bit, I'm going to get a little bit crass with this and just kind of make it a little simplistic, but trying to think about some of the difference, particularly between a reformist and criticalist view. So here what we have are some very distressing, I think, racial disparities in incarceration rates by race. So we're in law school. Law school is Socratic method. Law school is calling on people. I know there's some law students here. I just saw them sink like lower down to the chair. But here are our teachers today. No, so what would a traditionalist say? So what would a traditionalist say is the cause here of these racial disparities? What are we thinking here? It's about, well, let's get to something even, is the system working or is the system broken? So all you have to say is working or broken. Is the system working when you see this, or is it broken? I won't even look up. I won't call on you again. I won't interrogate. I won't ask for a citation. None of that. Is it working or broken from a traditionalist perspective? Yeah, it's working, right? It's working because there are these disparities. These disparities are a result of bad behavior in communities. Policing is working, the criminal justice system is working, right? If you want to change that, then people need to really have change in themselves, right? Well, what about a reformist? A reformist, is the system working or is it broken? I'm not looking, I promise you, I'm not looking. There's a little bit of that. I love this. We're all here to like have, yeah, I'm hearing a lot of that it's broken. And you'll hear this, the criminal justice system is broken, but we need to reform it, hence reformists, to get it to work. Because here what we have are vestiges of Jim Crow, vestiges of enslavement of persons of African descent, of black people. This is the reason here. Okay. So a criticalist, is the system working or is it broken? We got the. Someone said it like someone. We have a dean who's one of the lead, Dean Angela. She just shouted out the answer. She knows. She studied this. Yeah, you're right. So this idea that it's working as intended because why? Because racism is really about power. The purpose is to maintain power and to confer privilege. And let's talk about this, okay? So here, I just, a little bit of law school, I go to these questions all the time. Almost on the daily, in thinking about what is a racial analysis, because people often will say something is racist. People will often look at speech and say, oh, that was racist. And maybe it is, maybe, I'm not, but I'm more interested in why. Because if we know why a law, a policy, a practice is racist, then we can start to remedy it in some way. So here are some questions, and this is going to be some of our homework, right? Because we're in law school now. Remember how we were transported to law school. And so this is explaining what is critical race theory. So critical race theory really is at its core is talking about racial differentiation is about power. This idea that there are insiders, there are outsiders, and that our society and our law is really slanted in favor of maintaining the status quo. And it really explores we're not just thinking about, an issue of like a simplistic issue of like a black-white paradigm. What we're thinking about is relative insiderness, relative outsiderness. And we're not thinking about a one-dimensional sort of view of race. We're thinking about a multi-dimensional view. We're thinking about what Kimberly Crenshaw says, an intersectional view. So here, a race, class, ethnicity, we're thinking about sexual identity, we're thinking about ableism, we're thinking about so much of this. So asking, is the law, policy, or practice being applied in ways that preserve existing racial power structures? And we could do a whole analysis of the law that we now have after SFFA, right? Which is this sort of, you cannot consider race in the admissions process, okay? Now my colleague John Feingold would remind us in so many ways that this decision is very limited, okay, in so many ways. So please look at his work and let's not give more power to that decision than is required. But what about that? Is the law, policy, or practice being applied in ways that preserve existing racial power structures? And if we had more time, we would talk about this, right? We might think about who has had access to education, and what identities have been overrepresented in comparison to their numbers, and who have been underrepresented. Critical race theory is also about purpose. How is the purpose of racism being satisfied here? Is there a disparate impact on traditionally subordinated groups? And you know what, there's a lot of social science on this issue already, right? Because there have been some states that had similar restrictions, and we know that enrollments were lower and so forth. And we could talk about that quite a bit. We could talk about privilege, right? Now here, privilege of whiteness, this concept of whiteness here. Now, white can be a racial category, white can be an identity, but the concept of whiteness is something different. It's a construct that's changed over time. There have been times where people of Italian descent, people of Irish descent, were not embraced as a white. We see that Jews of European, more recently European heritage, may be considered white or white passing, but not treated as white, as we have seen with anti-Semitism. Also, some individuals from a racialized identity that comes under the large umbrella of MENA, Middle Eastern, North African descent, have not been treated as white. Although if you look at the OMB census form, may be asked to check white. Whiteness changes over time, but there have been legal privileges to whiteness here. So a big question, and I feel like this is one of the most important questions in critical race theory, is asking who benefits here. So in this new colorblind, that states don't even have a choice, who is benefiting? And clearly it's white students and racially privileged students, and that can change over time and space and so forth. The property of whiteness here. If you haven't ever read this work of Cheryl Harris on the property of whiteness and race, it's so important here. So whiteness, think about these entitlements that we were speaking about. How do they arise in this instance? We could talk about this a lot. Also thinking about the pervasiveness of racism. The idea that racism is not just something that happens once in a while, but Derek Bell talked a lot about this concept of pervasiveness and also permanence, that racism can be this norm, not the exception. And that racism can have this sort of permanence. It changes, it mutates, perhaps like a virus, but it's always there in different ways. So we can ask ourselves, if racism might be pervasive and permanent, how might it be manifesting in the application of law or policy or practice here, right? And so we might wonder then if Justice O'Connor was right, that in 25 years, she had said in the Grutter versus Bollinger case back in 2003, we won't need to have any kind of race-conscious admissions. But do we still need that? Is racism ongoing? Are there structural barriers in place that make it higher education less accessible? And then finally, a question here on perspectives. Are traditionally marginalized perspectives being heard? Are they being believed? Are their sources of knowledge legitimized? So these are some of the questions that we can use to do a racial analysis and to talk a little bit more deeply about race and racism. Now, something I wrote in the booklet is you don't have to adhere to a critical race theory ideology. It may only be that you maybe are a traditionalist, but by exploring this, you can understand why a criticalist or a reformist might think that something is racist. It helps us to talk across difference. It helps us to think about counter arguments and such. So So, I've had such a pleasure of teaching critical race theory over the years. And here, really thinking about these diverse perspectives on racism, thinking about the history of racialized groups, and thinking about how that continues currently under the law, and really thinking about this in terms of empowerment. So I often study with students a lot of different racialized history. And what we're seeing here is what was being taught in Tucson Independent School, Unified School District for many years in the Mexican American Studies program. And in 2006, 2007, 2008, really came under attack. And ultimately, the Mexican American Studies department was dismantled. And students, there's a documentary called Precious Knowledge. It's my favorite movie. I really encourage people to see this. And this was happening when I was studying with my students, and there were books like Richard Delgado's Critical Race Theory book. We had excerpts in our case book from Chicano, The History of the Mexican American Civil Rights Movement. These are books that were forcibly taken out of the classroom while the students were in it, and so forth. Very dramatic, but what a small minority of folks were saying is what's happening in Tucson is what we're going to be seeing across the United States, and that's really what happened. There's an activist, a conservative activist, Christopher Rufo, who has a journalist background and had gotten on a program, a Fox News program back in September of 2020, and really said, look, critical race theory is ruining the country, and there had been some exposure of these different DEI trainings and so forth. It was almost the next day, then President Donald Trump had him brought to DC and started writing up this executive order. And this executive order, obviously not in place anymore when Biden does not have this executive order continuing, but this language here is in the many attacks on critical race theory here that we have. And CRT Forward that comes out of the UCLA Critical Race Studies program is just an amazing resource if you're at all interested in some of these details. But what we can see is a tremendously high number of attacks on CRT, seeing, just this, almost half of all public school children are impacted here, and 20% of the legislation targeting higher education. It's quite interesting. This was, between 2021, 2022, this is continuing, and it's not losing steam in 2023. And I'm looking at the clock, so I want to get us to have a little bit of time for a discussion. So here, there are multiple legal challenges to all of this. We see challenges here through due process, challenges free speech, challenges with equal protection, labor challenges, academic challenges, and different state constitution challenges as well. The thing about the challenges, and law really is there for us and should be, but if we think about the Tucson case that we had here, ultimately, it was found the statute as it was enacted in part, but how it was enforced was unconstitutional. But by that time, the program had really lost steam, and this was an incredibly impactful program, higher test scores, higher college, and I mean dramatically higher, particularly for low-performing students who were previously low performing. So we have some movement where there have been some challenges, but I want to talk mostly now, and we have some time for some Q&A discussion, is about some unifying concepts here. First of all, what I've learned from critical race theory and from working in anti-racist movement is that this is really about all. This is really about love. This is really about freedom, and this is really about democracy. So here, thinking about all of these multidimensional ways that groups have been subordinated. It's not just about racism. Thinking about how the civil rights movement that informs critical race theory really focused on love. And that's something that I've seen time and time again. And ultimately, what do we all love? We all love our freedom. So the American Association of University Professors in 1940 really built up a statement of what academic freedom is. And you see when you read the cases, the courts routinely are referring back to that. Here we see our commitments at Boston University, just free speech. We see our commitments to academic freedom as it impacts the faculty and those who are engaged in the creation and dissemination of knowledge, how it impacts our students as well. And we've also heard this in the courts and how the court have really discussed how important, there's some big language here we have from Justice Frankfurter here, that teachers from the primary grades all the way to the university are priests of our democracy, right? That's something that we need to carry with us, that we need to carry forward with us, and how important having an open-minded, a truth-thinking, a critical thinking public is for those of us who have the status to be able to vote and to think about those who do not. But how incredibly important and how democracy really ties us all in together. I think about my teachers, and I have so many of my teachers here. Dean, I don't have you here because you're too young to be up on here. But when I think about my teachers, it has always been a space where all perspectives were shared, where they were all welcome, where all ideas were challenged, where everyone is valued. And that's what I want people to experience in my classroom, irrespective of their perspective on racism. And thinking of a path forward here, what have I learned from critical race theory is this idea of seeing our humanity, our collective humanity, and what a time right now in this world where racism continues to exist, where sexism, heterosexism continue to be pervasive, where tremendous acts of violence to our Jewish communities in the form of anti-Semitism in the United States, Islamophobia with hate violence happening even in our region, seeing people's humanity in a time of geopolitical crisis where the people have strong opinions. It doesn't matter what your position is, but seeing our humanity, tending to that suffering, and people are suffering in our community. They're suffering in our classrooms, our peers, our students. Thinking about what is the cause of that suffering. How can we really deconstruct that subordination? How can we address that subordination? How can we reflect to do better? How can we repeat this over and over again? I hope we can talk a little bit about how we embrace loving all, how we embrace our democracy, our democracy building, how we embrace academic freedom at the great Boston University, and how we can do that better in our academic units. And these are just some of the lessons that I learned from critical race theory. Thank you for allowing me to share some of my journey with you, and I look forward to learning more about your journey and feel in this community. Thank you so much.
Well, thank you so very much for your inspiring, informative, and questioning approach with us this evening. I think all of us will leave thinking and reflecting on what you said and how we engage with the world and with each other as human beings. It is time for some questions from the audience. Are there questions that anyone would like to raise with the professor?
I'm glad you said questioning and not questionable. It's a little bit hard, it's like the goodness I'm tenured, but.
I believe we have a question right here in the middle, yes? That's you, sir, yes. And then microphone.
Hi, Neil Myler from the Linguistics Department. I wanted to thank you for bringing the university's attention to linguicism, as you call it. It's something that I and some of my colleagues discuss in classes sometimes, but I'm really glad that legal minds such as yourself are looking at it as well. My question was that I noticed that a number of the opportunities for racism that you identified in the American legal system are things that you've inherited from English common law, including standard of evidence and trial by jury. Do you think that there's a legal framework that does better than English common law in this respect in preventing this kind of thing? Or are you happy about English common law and would rather just reform it rather than tear it down and replace it?
No, I think this is such a great, one of my premises is that you cannot be not biased, that we are all biased, but we need to be transparent. So my bias is that I love the common law, right? I have been so steeped into this, and that I think it's a fantastic, although flawed system. But I think that it's really important when we think about different models. And I mean, the idea of a jury, I think, is incredibly important, but we need a jury that truly is a fair cross-section of our community, a jury that really, even going back to the Magna Carta that talks about a jury of our peers, and including a jury of our linguistic peers is spoken in the Magna Carta. So there's sometimes you can even think of, we haven't reached that promise that's even there, because knowing that we have a jury, that ultimately something will be adjudicated by some people rather than just by judges who, no matter where they came from, ultimately become elitist, I think is incredibly important. But that's just a question that I think we should all think about. What could be better? Of course it could be better. How could we learn more from these other systems? Thank you for that. And please, social linguistics and racial linguistics, I love meeting people in linguistics.
Ben Wolzen, anatomy and neurobiology at the Med Center. I'm not a lawyer. But what strikes me a lot of times, and you mentioned this in the Tucson case, is that a legal challenge was made that was trying to disempower some people, and ultimately was batted down. But the legal system is kind of meant to be a very slow plodding system, and the politics, particularly in this age of social environment, in this age of social media, is so fast. I personally, on the outside, feel like the legal system is being challenged. The purposefully slow nature of the legal system is being challenged by the speed with which society has the ability to change.
Thank you so much for that observation. I think the Tucson example is tremendous, because by the time there was adjudication, it's really been pretty dismantled, and so have the opportunities of the have been. From
a legal perspective, do you have any thoughts on how to address that?
Yeah, how do we address that? Well, I think that we can't just wait for the courts, right? We can't just wait for the courts. I think that's why civil society is so important for us to be responding, and to be responding in our different institutions and units and spaces of influence, because those are going to occur much more quickly. We cannot rely on the slow-moving law system. The process is slow, and also the law is slower. So we need to be engaged. And I'm thinking of my colleague Aziza Ahmed, who had talked about this in the case of Dobbs, and had really where it clicked for me was there was so much reliance on litigation. Was an observation I once heard you speaking about. I hope that I'm construing it correctly. Versus that need to have that sort of engagement, not just not leave it just to the federal courts who are but to really be engaged in our civil society and responsive, and trying to think about changes that we can make that are positive.
Other questions? Yes, way in the back, and then we'll go to you.
Hi, and thanks for your lecture. Am I being heard? I just have to tell you that I teach a course, I'm a lowly adjunct at Boston College and here at Boston University on the courts and the LGBT community, a critical assessment. And this afternoon at BC, we talked about the Douglas case, we talked about the Parnell case, we talked about the Trump executive order, and we talked about the divisive concept laws. So intersectionality is not just a nice idea. It's something that came to me as a result of my experience teaching this course over the past 3 years. And I think I have to say that studying about structural racism inspires me as, with my students, we struggle as a kind of ominous chapter for us LGBT folks. It seems to be opening. So I'm really glad to, I don't know, we must be reading out of the same book, and I love that.
I'm honored to read out of your book. Yeah, no, absolutely, and there's so much more I could have said. Looking at these attacks on gender identity, sexual identity, and so forth are very pervasive, and we really see it here. It's tremendously concerning, and particularly for our young people who do not have access to learning about their identities and backgrounds. And I think that's why critical race theory really has to do not just about race, right?
We had a question towards the middle.
Hi, I'm Michael Ulrich, and I'm at the law school in SPH, and so I feel a little selfish taking up time when I can ask you in the halls. But it's something that I've been struggling with, my work on guns and race, and thinking about what we as sort of legal profession broadly, but also sort of as scholars, what do we do with the evolution of the court in terms of this sort of theoretical versus reality issue that I really appreciate that you highlighted, but also I think in terms of what rights they are prioritizing and protecting and which ones they aren't, and has a differential impact, and then the types that they have. And so all of that leads to, one of the things that I've struggled with this sort of guns and race piece that I've been working on, seems like forever, is it feels almost like just a mirror, right, of this is bad. And, working on the Rahimi case, right, where there's a tangible thing, it's easier to make sort of an argument, but then there's this kind of litigation versus scholarship thing, and it comes up in, trans cases. What role do you think that we as sort of legal scholars and people that embrace, critical race theory have? Is it to try to work within the system, flawed as that might be, to say, in my case, guns, here's the argument within Bruin as opposed to why Bruin is a terrible decision? Or is it to do something else, and what can we do beyond just sort of saying, here's a mirror, right, that shows how bad this is?
Absolutely. So there's a multidimensional problem is going to require a multidimensional response in so many ways. We do not want to give up, because it's the idea that the law exists, that things are operating within the shadow of that law. We have to continue to advocate in those spaces, but how do we have a tangible impact? And what about as scholars? And one of the things I think that are so exciting and what draws me to legal scholarship is that we can both have a theoretical impact, but also have relevance to people who are on the ground. And here, I don't just mean attorneys, I don't just mean activists, I mean impacted communities. And how do we transfer that information and make it accessible and do it in a way that is involving impacted communities, I think is incredibly, incredibly important, because who has the sources of knowledge? And that's one of the things I love about CRT, is the idea of the perspectives of impacted communities we can theorize together, and we can change some of our law and really organize and galvanize around that. Thank you for raising that. So important.
Is there a final question? We have 2 questions left in the back, and then we'll close with your question. Yes, you do.
You deserve a microphone.
Okay.
It's not that you need it, you deserve it.
Okay, so I am actually a prospective law student, but in undergrad, I wrote my capstone project on exploring the anti-racist possibilities of teaching through a critical whiteness studies lens. So I just want to thank you for this lecture first and foremost. But when we were talking about the protests and Trump's executive order, something that just came to mind, something I wanted to ask you and hear your perspective on, is this fragility and discomfort piece that opponents of CRT face when their whiteness is called to attention. And I wanted to understand or hear your perspective on why you think this is, or yeah.
So since you have the microphone and you deserve the microphone, is it that people are actually, there's fragility, or this fear of we can't have CRT because one of the reasons is it's causing a psychological damage to our children who are from privileged, racialized backgrounds? I'm seeing. Yeah. Well, you know what's interesting is this is the same folks who brought you the snowflake rhetoric, right? And so I don't know. I truly believe that people out in the world believe these things, but I don't know if some of the politicians all the time do, right? I don't know. I have a Gen Alpha and a Gen Z kid, and they don't seem to really care what people before them did too much, right? I mean, I don't want to get into this whole generation thing, but I don't know if people are saying, wow, my ancestors so many generations back this occurred. And I think maybe people aren't teaching, or if this is genuine, they aren't teaching CRT right. It's not about people's identities or about people who they are. It's about this idea, these constructs of whiteness and so forth that have a legal impact. It's about privilege, subordinating. And really, I think a lot about, Ibram Kendi talking about that someone could be a racist in one moment and then be anti-racist in the other. Any of us can perpetuate racism, sexism, heterosexism, and so forth at any time. And it's really about our resiliency, our self-reflexivity. And so I don't know. I don't think it's evidence-based is the thing. I don't think it's evidence-based.
We have a question from the dean, our final question.
Thank you so much for your speech, Jasmine. It's great. Before I wanted to say something about the person who described themselves as a lowly adjunct is John Ward, who is the very visionary founder of GLAAD, Gay and Lesbian Advocates and Defenders. Say that. But Jasmine, I had a question about, so we were talking about the system working the way that it's intended, and law facilitating subordination, and things being built into the law that basically enable subordination. And if you're a law student who's decided to come and work within the system, what do you tell someone who's like, the system's working as intended? How do you, what are the things that you should do to help to change that?
Right. Well, I think, first of all, I thought you were going to try to recruit the person who said they want to go to law school. So I was pretty much sure. And yes, come stay. I really think about what Derek Bell said when he talked about the permanence of racism. And that can really bump some people out. This idea, well, then why even work? But I know right now, because I walked around and I talked to a few folks, that I know there are people who came all the way from the medical campus. That's impressive, right? And they don't say I've noticed that this disease thing keeps happening, let's give up, right? But instead we invest more into it, right? We invest more into it, and that's what you get to do. Yes, and we can also be criticalist in our orientation, and then reformist in our actions as well, right? I think there's so much to be done. And I'm on fire every single day about what the law has to offer and how the law can work with so many different disciplines and professions and fields, really to invest equity for all people. And I think that it's endless, right? Let's put more resources into this. Let's have more, firefighters to address this fire that continues and that's impacting people across so many different identities and experiences.
Jasmine, thank you so very much.
Thank you.
Jasmine, thank you for inspiring us this evening, informing us. We hope this will look wonderful in your law school tower office.
It certainly will. Thank you so much,
Thank you so very much.
Thank you.
So again, we thank you for an inspiring and informing lecture this evening. A wonderful question and answer session. We also want to thank every one of you for joining us this evening. There will be a photo opportunity as we conclude here. The law faculty would like to join you for a photograph as we conclude, and students as well. So thank you again, everybody. Have a wonderful evening. We look forward to seeing you in 2024 University Lecture.